An ALR hearing, that stands for Administrative License Revocation, is a hearing regarding whether or not your license will be suspended. So anytime a person gets arrested for DWI and they either fail a test, breath or blood, or they refuse a requested test, breath or blood, their license can be suspended. But that suspension does not go into effect for 40 days after the arrest. And you have a right to a hearing, the administrative license revocation hearing, regarding whether or not your license will be suspended. Now, that hearing has to be demanded within 15 days of your arrest, or you lose out on the right to have that hearing. Now, once you demand that hearing, or your attorney demands that hearing for you, then that keeps the suspension of your license from going into effect. So even after 40 days from the arrest, your license is still good. You're still okay to drive. You'll usually be given what's called a temporary driving permit. And on that permit, about halfway down inside a rectangular box, it says, if you request a hearing, this permit will remain in effect until the administrative law judge makes a final decision in your case. So that's how you know that you're okay to continue driving. So we're able to win a lot of those hearings, and those hearings can take up to 4 months or more before we have them. But we're able to win a lot of those hearings so that you don't go through a suspension of your license or have to pay the $125 reinstatement fee. But more importantly, we can use that hearing as a chance to cross-examine the arresting officer at a time when that officer has not been coached by the prosecutor, so that we can pin the officer down on issues that might allow us to win your case.